Welcome to today's webinar entitled Managing Cross-Border Investigations During a Pandemic. This event is organized by the European American Chamber of Commerce, where Europeans and Americans connect to do business. My name is Yvonne Bendinger-Rothschild. I'm the Executive Director of the EACC New York, and I will be your host for today's event. About today's program, as Europe and the United States work their way through the COVID-19 pandemic, the lingering shutdowns continue to have a significant and in some cases a halting effect on cross-border investigations. Our experts from the US and Europe being represented by Germany and Italy, will discuss the regulatory developments and practical considerations in addressing these challenges. Recent developments in internal and government investigations on both sides of the Atlantic, practical aspects and how cross-border investigations have changed due to the pandemic, and what might be here to stay in terms of how these investigations are being conducted. Our panelists are Jonathan Halpern, he's a partner at Holland & Knight, Ilaria Corti, counsel at Portolano, Bärbel Sachs, a partner at Knorr, and Colleen Casey Faschel. She is a Senior Managing Director at FTI Consulting, and she will be our moderator today. With that, I hand over to Colleen. Colleen, the floor is yours.
Great. Thank you very much, and thanks everyone for joining us. Of course, as we would expect with the pandemic, we're starting this webinar with some technical challenges that we are trying to resolve in getting all of our panelists along, so please indulge us as we work through those issues. I'm going to sort of mention at a high level a couple of the technological changes that have really embraced the workforce in the COVID era. And we'll later in the presentation talk about some practical solutions to handle some of those things. And then we're going to talk about changes in practices and investigations in the US, Italy, and Germany. And so, of course, as we all know, we've needed to adapt to the way we work in the COVID environment. The use of collaboration technologies like Microsoft Teams, Slack, and others has completely exploded. And as we see in the investigation context, managing these sources of data has become a real challenge. For example, how do you collect and review chats from Microsoft Teams to determine if your employees are following your company's standards or engaged in improper conduct? And that's only the tip of the iceberg, to be clear. With employees moving to remote work, the water cooler conversations have shifted from those live, let's chat in person in the office forums to a plethora of different messaging formats. And while companies generally have policies that govern which applications employees should and should not use for business communications, we also have to recognize that employees may have taken liberties in those policies in light of the COVID environment. For example, messaging apps like WhatsApp, Signal, and others are widely used and very difficult to monitor. These emerging technologies present a number of challenges in terms of monitoring, compliance, collections, and just participation in working with the government in investigations and those kinds of things. Those are just a few developments from a technological perspective that are impacting investigations and how companies and counsel have handled those. Later in the discussion, we'll talk about some practical considerations in terms of using those technologies. And right now, I'll turn it over to Jonathan, who's going to talk about some developments he's seeing on the legal side in terms of investigations.
Thanks, Colleen. Let me start at the outset is don't believe everything that you read. And for example, the designation below me shows Colleen's name, so she may want to disassociate herself with me and my comments. That's understandable. I'm Jonathan Halpern. Pleasure to be with you if I can't see you and be with you in person. I wanted to touch on a number of the trends as in developments for Justice Department, the SEC, regulators, with respect to investigations and internal investigations, how they're changing, what's developing into the new normal. And there's not an easy answer to summarize all. There's lots to talk about. On the one hand, there's been a pipeline of investigations and prosecutions, and we've seen them come to the forefront now. And I'm going to talk about investigations, grand jury proceedings, and court proceedings, and some other priorities of the Justice Department and SEC and regulators, things that your clients, that companies can do, obligations that are imposed on them, added requirements during this period of pandemic. First of all, there is a wide variety. As I said, first of all, there's a pipeline of investigations, and they've been continuing even though prosecutors generally have been working remotely, as many judges have. Grand juries, however, have been working in person, with some exceptions. This is in the New York area. New York State grand juries have been convening in person at least since the summer. The Southern District of New York, for example, appears that grand juries were convening in person, and Judge McMahon, as chief judge, issued an order that allowed the grand jurors residing in northern communities in the Southern District to participate in the federal courthouse in White Plains, and by a hookup, a video or telecommunications hookup to fellow grand jurors convening in Lower Manhattan to prevent them from having to travel to Manhattan, and also to help protect the distancing from the gathering. That raises certain issues. We can talk about that later on, but mostly about secrecy and whether the individual's rights to have a grand juror fully participate, review, and listen to all of the evidence, all of the witnesses, and convene together as one body in a secret way. The courts are coming back to a certain extent. It seems that to individual judges are setting both civil, in some cases, and criminal trials. It's not the routine. And by further extension of existing court orders, the judge has allowed, with the defendant's consent, that certain felony pleas and sentencings proceed by way of video conferencing. There are exceptions, and so where that isn't consented to, and other extraordinary cases, they're in-person proceedings, such as I say, felony pleas and sentencings. There are exceptions that have been set out in the judge's order that cover arraignments, presentations, and misdemeanor pleas as well. So what are we seeing? What are the added obligations? And the SEC in particular, DOJ has come out about this and said, look, we're very concerned about investor fraud, about people really, for us in the United States, victims of COVID-related fraud, those companies that be falsely representing that they have a cure, a treatment, a vaccine, PPE. And so there are added obligations, in particular the SEC most recently this summer has issued a client alert for investor firms, for broker dealers, and then say, first of all, because most of your employees are working remotely, you have to have added supervision over them, making sure that they're not offline and conducting investor-related business on their own devices, for example, or up to their own devices. And so that there's more strict monitoring, more strict vetting, due diligence for investments. And there are added obligations for security of funds, of investor data. And so that requires significant collaboration with IT and other departments. I should also say that there's been an initiative by the Justice Department with its counterparts abroad in Europe, but not only in Europe, in Asia and elsewhere, to combat COVID-related crime with an emphasis on cybercrime, online fraud, intellectual property crime, public procurement corruption here in the United States. That would be false claims and other various frauds, gender-based or domestic violence, trafficking, we're seeing that, as well as the spread of COVID. And this is through an office of the Justice Department called OPDAT, which sends prosecutors, agents, or at least has them collaborate with counterparts in various countries. And so what are we seeing in terms of cases being prosecuted, investigated? I think there's still a pipeline now of the developing investigations. But we're seeing money laundering investigations and sanctions investigations, anti-corruption. There's still focus on securities fraud, market manipulation, market-related activities, and really with a focus on integrity of data, records, communications, other systems. One last word before I turn it over to Babel is, and this kind of dovetails with what's going on in Europe and privacy implications and concerns. One of very important focus of attention for Justice Department, SEC, and other regulators is the ability for whistleblowers to come forward and have protections and to make reports of alleged wrongdoing so that companies can timely, fully, thoroughly investigate as appropriate. And so it's very important for your clients, companies, to have in place systems now that protect those rights, that have the communication stream so that whistleblowers and others can come forward with reports of allegations of misconduct, and that they're protected, and that there are systems that support those protections, and that as a result of those alleged credible, or even if it's a questionable allegation of misconduct, that they're responded to, addressed appropriately, and that there are systems in place to right away to preserve all data, to collect all data and records, and follow up appropriately. So I think at this point, I'll turn it over to Babel and look forward to further questions and addressing other issues as the panel continues.
Jonathan, I actually think we're going to go to Ilaria, who's going to talk about some developments in the EU.
Yes. Thank you, Colleen. Thank you, Jonathan, for this interesting overview. I believe that the developments we will now talk about, Barbara and I, in Europe, even if not directly connected to COVID-19, in any case, will have a significant impact on the trends we are observing in the US, in Europe, on the digital acceleration we are experiencing, and in general on the way we conduct investigation as well as the regulators. Thinking to the most important development in Europe, I believe that the first place go to the Schrems II judgment of the Court of Justice that in July invalidated the privacy shield for the transfers of data from Europe to the US. And this is not only a decision that had an impact in Europe, but also abroad, because in Switzerland and in Israel, authorities came to the same decision. As Colleen was mentioning before, data management is crucial in internal investigation, and in cross-border investigations, data transfer across national borders are very common. And of course, even before, it was necessary to carefully assess the data flows. But now, after the Schrems ruling, things changed. Because first of all, the Court of Justice ruled that the companies, and they are around 5,000 in the US, that use the privacy shield for transferring data from Europe to the US can no longer rely on these tools. And so they must shift to different solutions. And one of the solutions can be using standard contractual clauses, But standard contractual clauses as well have been impacted by the Schrems II ruling, because the Court of Justice said that when a European company is transferring data abroad to a country where privacy laws are not that protective as the European laws, additional safeguards, standard contractual clauses have to be implemented. But the issue now and the challenge is to understand what are these additional safeguards, because the Court of Justice didn't say anything regarding this, and the European Data Protection Authority as well is still silent. So the European Data Protection Authority issued frequently asked questions, but just explaining the judgment of the Court of Justice, but from a practical standpoint, didn't give any kind of advice regarding the possible additional safeguards that should be implemented with standard contractual clauses. This means that companies that now that relied on standard contractual clauses now should review them and try to understand how to manage the data flows to the US. And as an interim solution that cannot be a standard solution, companies may also think, especially in the investigation space, to rely on the derogation of Article 49, which applies when the transfer is necessary to defend a legal claim abroad. But it is something that the data protection authorities in Europe stress to be considered very carefully, because in any case, not all the data can be transferred abroad, so it has a very limited scope. And I think that in order to have some practical advice regarding this, maybe verbal can be of help, because the German Data Protection Authority is the only one in Europe that issued guidance regarding standard contractual clauses and how to interpret the Schrems II ruling. So, Barbara, I leave the floor to you.
Thank you, Ilaria, and I fully concur with everything you said. Also in Germany, the Schrems II ruling was received with shock, basically, because it cut two ways that allowed for data exports, like Ilaria explained. The first one based on the privacy shield, and the second one based on the standard contractual clauses. And we have been very lucky in Germany because the data protection officer of one Bundesland. Germany has 16 Bundesländer, states, and one data protection authority, the one based in Baden-Württemberg, very commercially friendly. It's the land where much of the automotive industry is located, and where all the hidden champions in Germany are located. Not all of them, but lots. So you have a rather business-friendly government there as well, and they dare to state that based on additional contract clauses, not the standard contractual clauses, but additional contract clauses, data exports from Germany to the United States can be carried out. And of course, you have to look on a case-by-case basis, but there are some elements that could be included in additional contractual clauses, and based on those additional elements, data exports can be okay. And that statement allowed us, for example, to continue our cross-border investigations. We are currently dealing with US law firms, for example, and also to, of course, allow businesses to continue data exports. I mean, let's face it, the European economy is dependent on exchanging data with the US. And these elements are, and you will see that it's not, you know, they are not easy to manage, but at least on a case-by-case basis, you can come to the conclusion that in this specific case, a data export is allowed. And the 6 elements that are contained in that decision are consent of the data of the persons concerned. That can be extremely tricky. The next one is encryption. If the data is encrypted, of course you can export it, but that usually makes no sense because you would want to have your American counterparty look at the data, evaluate the data, etc. So that's in that case, encryption may not be a solution. Redaction, anonymization, that can be one solution. Also, simple information of concerned individuals, and an obligation of the importing party in the United States to use all legal remedies available to counter a decision by the US authorities to seize the data. And the next one is an arbitration clause stating that if there is dispute about what data can be exported and what not, a court located in the European Union should be the competent court. So these are possible elements, and based on these elements, we have been able to continue data exports, but of course it needs to be, we need to look at the situation very closely. It's only one Bundesland which has decided this way. And of course, we will need to follow what the other authorities say in Europe. But for the time being, we think it's safe to base decisions on what this authority has said, and to exclude criminal liability risks for our clients. I don't know, maybe
we actually have a question. We have a quick question that falls along those lines of the point that you made with respect to consent. And Ilaria, I don't know if you've seen whether consent is a viable alternative in whether it's decisions in Italian jurisdictions or other interpretations of the law that you're seeing with respect to consent.
Oh, yes, thank you, Colleen. As Barbara was mentioning, asking for the consent of data subject is not the best option to be considered, because according to the GDPR and in general to the local laws, European local laws on privacy, data subject has the right to decide at any time to stop the processing of data. So if you are in the middle of an internal investigation, you cannot, of course, use this data anymore. So it's very tricky, can be not efficient. And in any case, there are also discussions regarding the fact that maybe consent of an employee to the transfer of the data in its emails is valid, because regulators can assume that the consent given by the employee is unbalanced given the employer-employee relationship. So to conclude, I think that the consent is not the best solution.
And here again, I fully concur with Ilaria. My data protection lawyers tell me it's not a viable option. Yeah, that's usually not possible.
Thank you. Ilaria, I think you were going to talk about some anti-corruption provisions and case law around corporate criminal liability of foreign countries.
Yes, I decided to talk about these two topics in connection with our discussion on cross-border investigation and COVID-19, because in these new developments in Italian law, I see that these developments can have an impact in the COVID-19 era. In fact, with respect to government investigations that, as John was mentioning before, also in Italy now are very focused on cyber frauds, corruption in public tenders, especially with the corruption crimes. Now, Italian public prosecutors have the power to investigate into corruption, international corruption, by using Trojans, so spywares. They were not allowed to do this before, and so they can launch these spywares on the mobile devices of people that now, as Corinne, you were saying before, now people change the way we are communicating. We do not have meeting in person, so people around the globe are discussing with telephones, teleconferences. So Italian prosecutors now can, it's easy that they run in conversation related possible agreements and whatever, and maybe this can have an impact in cross-border investigations and investigations into corruption. And regarding the corporate criminal liability, and so this international development from the Italian perspective, we had the ruling in April from the Italian Supreme Court that for the first time established Italian jurisdiction on foreign companies with no offices in Italy that failed to prevent the crime committed by their associate in Italy. This is something that can be interpreted in the law, but we didn't have a ruling from the Supreme Court so far. So this is sort of new trend in Italy, because this could lead, together with this new power of public prosecutors, to more international cross-border government investigation cases. And with respect instead to the internal investigations, the novelties that we have on the anti-corruption side is that for the first time, again, now we have provisions that encourage individuals and companies to self-report. Self-report is something that it's not in our culture. It's very difficult. It's very different from the common law countries. So for the second time, because the first time was related to tax crimes, but in corruption cases, individuals who self-report and carried out investigation, and companies may have benefit from this conduct. So individuals cannot be punished, while companies may have a significant reduction of the penalty in corporate criminal cases. And so I think that this could be something that will, together with, in general, I think that in Europe we are observing this new interest on internal investigations, and I think that maybe we will have in the future both government and internal investigation coming from the Europe instead of from the US.
Do public prosecutors and courts consider internal investigations valid measures to mitigate criminal liability?
We do not have laws regarding this specific question, but in general, in practice, what we see is that if you cooperate, if you show the internal investigations result, the remedial actions that company implemented after having conducted an internal investigations, public prosecutors are more open to discuss penalties and possible solutions.
And Babel, do you see similar things?
Yes, actually, I was going to talk about a bill that has been introduced into German Parliament just very recently, and this bill explicitly makes efforts with regard to internal investigations a mitigating factor when sentencing a corporation. First of all, it's worth noting that in Germany, so far, corporations, companies cannot be subject to criminal sanctions. And this is being under debate has been under debate for quite some time. And under the recent scandals, the diesel scandal and some other scandals in Germany, there has been the debate has been heated, and this law was introduced, and the draft law basically has 4 main ingredients, and the first one is that it contains an obligation for the prosecutor's office to actually sanction the corporation in case there has been a breach by management, or in case there has been a violation of supervisory duties. So if this bill is being passed, we will see enormous pressure on corporations and companies to actually see that they reach an agreement with the public prosecutor's office in order not to be prosecuted in case of a violation. And the second ingredient is basically an extension of jurisdiction, since the prosecutor's offices will also be able to go after violations that have been committed abroad by persons belonging to the company, which is under German criminal law usually not the case, only in exceptional cases. The fourth ingredient is also something that will hit business hard, and it's a rising of the threshold of the fines that can be imposed on companies, and that's 10 million euro or 10% of the turnover, whatever is higher. So this will basically be a huge increase on the penalties that can be imposed, which will also have quite some effect in Germany. And the fourth one is the one you alluded to, Yvonne, and that's the role of internal investigations. And if the law will be passed as introduced, there will be a 50% benefit if the company conducts an internal investigation. But there are some requirements the internal investigation needs to fulfill. There are some substantive requirements. I would say they are state of the art already. If you seriously conduct internal investigations, you fulfill these substantive requirements. But what you also will need to do is you will have to separate the defense from the internal investigation. So if you want to have the reduction, the defense lawyer can no longer be the one conducting the internal investigation, and that will have a tremendous effect on the internal working of the law firms, because right now in Germany it's usually the law firm helping the company with the defense that is also conducting the internal investigation. And we will see a change in that if the bill comes into force as planned. But that's receiving a lot of critique, also because like it is provided, the public prosecutor's office could seize the work that is being done with the investigation. That's of course something you wouldn't want to do. You wouldn't want to have as a possibility. Of course, you would want to have that the work is under privilege. Yeah, that's basically what is being discussed in Germany. It really looks like internal investigations will become even more important compared to now, although internal investigations, of course, have a big role in Germany already.
Thanks very much. We can now sort of shift the focus and talk a bit about practical considerations and challenges in both cross-border investigations due to the pandemic and sort of preparedness now and going forward. And Jonathan, I think you were going to talk a bit about some legal and practical concerns around some of the meeting platforms and other such things that are occurring in the United States.
Yeah, I mean, for one example, is grand juries. And we're saying in New York and New Jersey, it appears that the grand juries are conferring in person, with some exception where there's a remote hookup. However, it's dependent on the jurisdiction. In some, such as I think Texas and Arizona, they're virtual gatherings. And I think there was a recent Wall Street Journal article that essentially said, no excuse to grand jury service or duty when you can do it from your bedroom. And so there are Zoom grand jury proceedings that I think are subject to challenge because principally you're concerned that the proceeding be conducted in secrecy as it's required to be, so that the evidence that's put forward, whether it's a witness's testimony, whether it's document or other evidentiary object, is considered in secret, as well as the subject matter of an investigation, and that the matter is privileged. And so if you have a Zoom grand jury proceeding, raises questions about the secrecy. What measures are taken, for example, to protect the secrecy and prevent someone's recording or someone's entering a room with a Zoom image of a witness of an exhibit. And so we've got that issue, as well as an individual's right to have each grand juror hear and see all of the witness's testimony, all of the evidence, not distracted. As most of the audience, I assume, understands what grand jury is an independent investigative body of up to 23 members, citizens from that particular district. Requires a quorum of 16 generally, and a vote of 12 to determine whether there is sufficient evidence, in this case by a preponderance, slightly more than not, of guilt of a particular individual for particular crime that's alleged. And so these are serious constitutional issues. And so that's in the grand jury context. There was one report, I think it was in that Wall Street Journal article, where a defense lawyer challenged the return of an indictment when it was either virtually or Zoom or by other virtual remote matter. And before I think the court could hear it, the prosecutor went ahead and re-indicted with a grand jury being impaneled in person and serving in person. And as the audience may well know, a subject or target doesn't necessarily have the right to be in the grand jury, or appear before the grand jury, depending on the circumstances. The putative defendant's lawyer does not. It's really just a lawyer for the government. It's a witness, it's the grand jurors, it's the court, it's the grand jury reporter, and an interpreter if necessary. So that's one example. Another example, short of a grand jury proceeding, is a prosecutor or regulator wants to conduct an interview by Zoom, for example. Or an internal investigation that's done by Zoom, and you're representing a company. There are various issues, there are technical issues. One, that's always paramount is privilege. Obviously, the company, in an internal investigation is going to hold the privilege, and that means that it's attorney-client privilege. And so when you're conducting an interview of a witness, of an employee, as part of the Upjohn warnings, you're informing the witness that the communications between a lawyer for the company and the employee are to be held confidential and therefore privileged, with the employers holding the privilege. And so we want to take appropriate safeguards to protect against anything that would interfere with the confidentiality of those communications, including that there's not a third party in the room or participant in the interview. For example, it's not being recorded. You also want to have control over over the witness, and you want to be able to look the witness in the eye and to get answers that are unassisted. So, for example, does the witness have a cue card or other notes or other information that's off camera? Is there, what is the protection for kind of technical difficulties if there's a challenging question or if there's some interruption to the proceeding? On the other hand, if you are representing the individual, there is kind of almost a technological barrier, perhaps, but there are things that can be introduced to help prevent this from objecting timely if there's an issue or question that's being pursued that's outside the scope. And the witness may, be because of some delay or for some other reason, they already have answered. There may, just because of the technology, be an interruption or a distortion of what's said. I mean, there could be freezing of what the witness's statements are. It could not capture everything, and especially in an investigation by federal prosecutor, by FBI agent, by SEC regulator, attorney. And so it's critically important that the witness be heard and be heard in entirely. And so there are, various challenges about proceeding this way, and whether an interview can, in fact, be conducted safely in person. And if not, then there should be certain ground rules that should be enforced and reduced to writing, so everyone is clear on how the interview is being conducted. And then you have, of course, the question of introducing exhibits to the witness. Is that on the screen? And there's some very good technologies that allow for that without, if you're representing the company, for example, without giving an advance lead, unfair lead that could compromise your investigation, by providing the documents to the lawyer himself or herself in advance of the interview. There are protections also that you can, and I know heard about the lawyers doing this for depositions where documents are delivered and they're sealed, and you have a court reporter or some other appropriate third-party witness, the kind of unsealing of the documents to present to the to the witness. And also, as lawyers, there are obligations on being familiar with the technology and making sure that it's appropriate, that there are safeguards in place, that there aren't extraneous documents, for example, that somehow are taken, that all the parties are appropriately identified on the screen, notwithstanding some mislabeling that may occur. So those are various but very important issues on both the criminal side, the regulatory side, and for internal investigations. And this is not even notwithstanding the privacy, GDPR, and other privacy issues that we have that attend European witnesses or evidence or data. I will say, as a counterpoint, and just in my experience and familiarity, while the Justice Department continues to pursue its investigation and seeks records abroad, and it often asks companies or affiliates in the United States to voluntarily provide those documents. That implicates European privacy laws, and so the Justice Department can say, well, look, we really want to cooperate. We want you to drill down on the legalities and the protections and the practicalities of coming forward and saying how you can make this work, how you can provide us, the law enforcement agency or the regulator, with the appropriate, the appropriate data. And I was going to say, as a counterpart to, the new normal or the old normal, I'm aware of one kind of European-based investigation where law enforcement agencies just reached out directly to an individual or individuals that were seeking to obtain information from in the United States, kind of bypassing the regular treaties and other protocols that we go through. So kind of, and even with a request to appear in person in Europe. So this seems very anti-GDPR and anti-privacy, and certainly anti-realities of the pandemic world. So we're seeing all kinds of things, but I think generally there's increased cooperation. But that's one example of the kind of the challenges for Zoom and other remote virtual technologies that we're dealing with in investigation.
John, one
Thanks,
very
Jonathan.
And to say
we
this.
have a quick audience question, which kind of piggybacks on many of the things you just commented on, Jonathan. And the question is, even though there are some challenges in gathering data and statements, et cetera, there's also an easier component in the sense that we're not flying all around a country, the globe, to gather information and that kind of thing. And the panelists or the audience member is curious as to whether we think that this method of conducting investigations will continue after travel and in-person meetings are no longer restricted. And so maybe Babel, if you want to start, and then we can go to Ilaria and Jonathan for their thoughts on that question, because I think it's probably something we're all thinking about on a regular basis as to what it'll be like after this, because there certainly are efficiencies that we've gathered through these processes.
Yes, I had one brief reaction to what John last mentioned, authorities forgetting about protocol. We have seen this in the sanctions area in Germany, where the US authorities and US congressmen reached out to German companies directly without following protocol. So this can be a very interesting topic for for another session. With regard to the technical changes that we see now and how they impact internal investigations, maybe a brief spotlight on Germany. Since fortunately up until now the pandemic has not hit so badly, the authorities work like they did pre-pandemic. This may also be because of a lack of digitalization, but German courts need to base their convictions on witness evidence and physical witnesses in front of them. And we have even had one occasion where the judge refused to base a judgment on a witness statement made by a witness who wore a mask. So she sent everybody home, telling everyone, I cannot base a judgment on a statement by a person wearing a mask. I cannot evaluate face reactions, etc. And we are doing this again when I can hold this session without masks. I think that's a very good example, you know, to understand what's going on in Germany. From the public prosecution side, everything is going on as usual, except for it's much slower, yeah, because the seatings in the courtrooms have to be with the necessary distance, so only few courtrooms can be used, so much less courtrooms are available, which makes the scheduling much more difficult. And what we see is that in the very important cases where the focus of the public prosecution lies, for example, the diesel scandal cases, etc., there you have authorities which act quite quickly, but in the areas where there is much less public spotlight on the cases, they may even be as important for the companies as the other cases. But if there's not as much public pressure on the cases, they go much slower. And with regard to our own internal investigations, what we experience is quite like what Jonathan has already said. So I'm not going to repeat elements of that, but basically, I mean, we are conducting our e-searches just as before. Colin, the difficulties you alluded to in your introduction, I think we will see them in the future. For right now, the internal investigations are around email exchange and do not focus so much on the new technologies yet. But of course, that's something for the future, and which will be very important. One important thing for Germany, if you, as a US company, have a subsidiary in Germany, please make yourself familiar with the specialties in Germany in advance, before you're even thinking about conducting an investigation, since there are some special features that can make your life much easier if you know them in advance. For example, please prohibit your employees to use their office technology for private use. If you do so, you can access the equipment much more easily than if you don't do that. But Jonathan was quite treated this quite exhaustive already as well. The interviews we're conducting are much more difficult. I just want to add one more point. It's even much more difficult to get the witnesses to agree to be available. For example, it's now much easier to just state you have a cough or some sickness and it's infectious and you're not moving. When we had one important witness who stated that for several months, and we have been able to interview him, but only after waiting for quite some time. And of course, it's much easier to interview somebody being in a room with you rather than on screen.
Thank you. To the audience question of how you think things will change when we get past the current restrictions in COVID. Like, will there be pieces that we keep that we've adapted to in this environment and that kind of thing? Ilaria, I don't know if you have thoughts on that or want to comment on that.
Yes, it's it's an interesting question because there are, as Barbel and Jonathan were saying, there are a lot of concerns regarding conducting trials remotely or conducting internal investigations remotely. But of course, there are benefits because we can reach for internal investigations witnesses in a quick way, so just without going on the other side of the world. So I think that it really depends on the kind of activity. Thinking to Italy and how courts are managing proceedings, I don't think that we will shift to remote trials, because now we have this rule in place that the defendant need to agree on the remote trial when there is the final statement discussion, or when there is the interview of witnesses. So when there are important phases of the trial, in order to have a remote hearing, the defendant should agree. So it's just this provision, I think, that highlights that probably in future we will not move to a complete remote trial. And with regard to the internal investigations as well, yes, there are some aspects that are positive, but in general, this is my personal feeling. Conducting interviews with witnesses, it's not the same. Also, the fact that you need to share documents and you are not sure that the person is not taking pictures of the documents, it's something that I think you cannot prevent. You can say in advance that, oh, you're not allowed to do so, but you know,
right.
You cannot prohibit people to take pictures. So let's see.
I definitely think that's true. And from the technical perspective of gathering information and that kind of thing, I don't think we will go fully back to forensic teams deploying around the globe to gather information and that kind of thing. But at the same time, I really think it will be a matter of the facts and circumstances of the matter. Technology has certainly facilitated a lot of ways to gather information remotely and really comprehensively gather that. So there are a lot of efficiencies there, but I think sometimes it's still very similar to meeting with a witness, being on premise to understand the structure and, you know, see a room of data just sitting there that if you relied on someone to tell you this is where all of the information is, you would miss. So I really think maybe some of the technological advances will certainly continue to afford efficiency to processes and allow you to get information more quickly. But similarly, I don't think we'll just rely on people identifying information and turning it over and that sort of thing. I also appreciate that we are almost at the top of the hour, so I want to give our panelists the opportunity to share any closing remarks or ending comments. And Jonathan, I don't know if you want to start.
To that point, I think it was a very insightful question. I think, I think this approach will have legs, and I think meaning that the approach to conducting investigations remotely, there will be some benefits that will retain with the options to follow up with in-person pursuits if it's inadequate. And I think that's going to be room for negotiation, and I think there are benefits to these tools as well. But recognizing the challenges will also offer an opportunity to be able to address them where they can be resolved.
Terrific, thanks. And Yvonne, I'll turn it back over to you.
Yeah, thank you very much. Unless any of the other panelists would like to add to Jonathan's closing statement. Bärbel, Ilaria?
No, I think the message is very clear. It's now time to prepare for the investigation in the future, and of course to take into consideration all the new technologies that are mushrooming currently. I think this will be very important for future investigations.
Yeah, I fully agree with Jonathan and Bärbel and Colleen.
Very good. So with that, we conclude today's webinar. A big thank you to our panelists for sharing your insights on this complex issue, and thank you to our audience for joining us for today's discussion. And to enable networking in this virtual time, we will make a list of the attendees available after the event. And if you're a member of the EACC, and you would like to connect to any of the other participants, we will be happy to facilitate that. And with that, enjoy the rest of your day. Thank you.